All right, we're back. Objections at deposition. In many jurisdictions, you may not be required to state the grounds for objection during a deposition. Instead, you object to the form or make some similar statement that preserves the record without specifically stating the grounds for your objection. Since there is no judge at a deposition, grounds for objections must be deferred to a later time when a judge can consider the grounds upon motion of the objecting party. If possible, however, give the grounds for objection at deposition, such as objection calls for speculation. The deponent cannot testify to what Dr. Phil Popper was thinking when he prescribed Prozac for the defendant's daughter. Expect a battle with opposing counsel at nearly every deposition. The typical lawyer will argue over every little detail because there is no judge present to stop him. He will do all he can to intimidate you and, in many instances, go to great lengths to intimidate or confuse the deponent witness to get testimony that will hurt your case. If the opposing lawyer takes any action whatsoever that is inappropriate or in any way contrary to the rules, object and state your grounds. Or, if local rules require you not to state your grounds during the deposition, say objection to the form or whatever substitute for stating the grounds is used in your jurisdiction. If the lawyer drums his pencil demandingly on the table, leans threateningly over the table towards the deponent, or makes menacing faces as he asks his questions, it's a simple matter to make your record by saying, let the record reflect that the counsel for the defendant is trying to intimidate the deponent by drumming his pencil and leaning across the table with a menacing stare. Plaintiff objects that counsel is badgering the deponent. You aren't going to make any friends this way, but lawsuits are not designed as a place to make friendship. Remember that pencil drumming, leaning across the table, and making threatening faces cannot be recorded by the court reporter at a deposition. So, if you wish to preserve your objection to such errors for appeal, you must describe the objectionable action and make it clear on the record that you object to same. Indeed, if such tactics are not curtailed after your objection, you should consider terminating the deposition until you can bring the abuse to the attention of the judge. If objection alone doesn't stop the other side's unfair and unprofessional practices, threats of terminating the deposition to telephone the judge usually will. I've done this dozens of times and always with the desired effect. The nonsense stops. As with any proceeding, failure to object at a deposition may waive your right to object later when the other side offers the use evidence obtained at the deposition. As at trial and hearing, be prepared to object contemptuously, and if the rules allow in your jurisdiction, state the grounds for your deposition's objections. Rulings. In many jurisdictions, preserving your objections requires you to move the court to rule on them. If the court doesn't voluntarily rule on its own, the judge needs to decide. For example, suppose opposing counsel asks his witness a leading question. Isn't it a fact you were standing on the corner of Main and Elm at 2:30 the day of the accident? Objection, leading. You chime in. The judge says nothing. The witness goes ahead and answers the leading question. If you do nothing, your objection may be worthless. You must take an assertive stance when fighting in court. Do not be afraid of the judge. He is nothing more than a referee. Do whatever must be done to make your winning record for appeal, or you will regret not doing so when it's too late to fix the error. To fix the error. If a judge fails or refuses to rule on at the time you object, move the court to rule on your objection. This makes the record clear. This shows the judge did not overlook or merely fail to hear your objection, but that he intentionally, knowingly, and willingly refused to rule. This is judicial error on its face. Appellate courts do not like to see it when see it and will react favorable to you. If you make it clear that the judge wasn't simply hard of hearing or thinking of something else at the time when you stated your original objection. If the court fails to rule, move it to do so. Say plaintiff moves the court to rule on plaintiff's objection, or defendant moves the court to rule on defendant's objection. Or if you are the defendant, defendant moves the court. Merely making an objection may not be enough unless the court rules on it. The objection, the object of objections, remember, is to make a winning record for appeal. Saying something like, plaintiff wishes to make a record of its objecting to the statements made by defense counsel is sufficient. That's not an objection at all. Wishes are wishes, not objections. The court may ignore wishes without fear of being reversed on appeal, nor are appellate courts required to consider your wishes as official objections. You cannot ask a court to rule on a wish. If you want to make an objection, make the objection. Stand to your feet. Look at the court reporter to make sure she is still typing, and in a voice loud enough for the court reporter to hear and record, pronounce that powerful word clearly and without apology of any kind. Objection, Your Honor. Throw a flag on the play before the ball moves an inch farther. Take no prisoners. Objections need to be contemporaneous, but they are also to be ruled upon. If the judge refuses to rule on your objection, move the court to rule. Say, Your Honor is moved to rule on the objection before proceeding further. If the judge refuses to rule, you should, of course, object also to the refusal to rule. Say plaintiff objects to the court's refusal to rule on plaintiff's objection. Make it clear that the reasons for not ruling is the judge's refusal and not some consequence of your own inactions, not speaking loud enough, or some disturbance outside the courtroom window that temporarily grabbed the judge's attention. Remember, we are working to record the judge's errors. Failure to rule on your objection is a serious judicial error. So if you won't rule on it, we take exception to it as an appealable issue for failure to make a ruling one way or the other on the objection before the court. There's an issue, a matter before the court, and the judge failing to act, you're going to take exception to it as an appealable issue, as a palpable error made by the judge, right? Preserve it for appeal by objecting. It has been held that a judge's refusal to rule does not prevent an appellate court from reviewing a case where the judge intentionally ignored the objection. By objecting to the judge's failure to rule, you make your record clear that the court did not merely overlook your objection, but intentionally, knowingly, and willingly refused to rule on it. A serious judicial error. Object in a timely manner and forcefully, if the situation calls for it. If the judge does not rule, move the court to rule. If the judge refuses to rule, you have made a strong record of his error for appeal. Then if leading questions are asked and answered over your objections, or hearsay is allowed to come in over your objection, or other harmful errors are permitted over your objection, you have made an effective record for appeal showing you objected in a timely manner and that the judge wasn't simply asleep at the time or distracted by some factor causing him to miss hearing your objection, but that he refused to carry out his duty. The appellate court will then decide whether the error was harmful or not and rule accordingly on appeal. In most cases, if a judge fails to rule on your objection and you move the court to rule, the judge will comply with a ruling rather than risking having his error recorded for an appellate court to criticize. If you don't move for a ruling, the other side will gain unfair advantage and you may be unable to cure the error on appeal. If you move for a ruling and the judge still refuses to rule, you have made a record that the failure was intentional, knowingly, and willingly, and the appellate court will be properly advised so it can teach the judge his errors. Renewing objections. Failed objections, i.e. those the judge overruled or ignored, should be renewed to preserve them for appeal. The time for renewing objections is not fixed in stone. However, times proper for renewing objections include close of your side's presentation, close of your opponent's presentation, if any of your objections on jury voir dire, voir dire, VOIRDIRE, were overruled or ignored, then at the close of voir dire and prior to the jury being sworn, and at close of the case before the jury retires to deliberate. With regards to renewing objections at the close of voir dire, the Florida Supreme Court explains that the purpose of requiring renewal of a voir dire objection before the jury is sworn is to make it plain to the trial court that the defendant has not abandoned his earlier objection and to give the trial court an opportunity to reconsider its earlier ruling. Carratelli versus State, Carratellie versus State, 915 SO period 2D, 1256, Florida in 2005. Failure to renew your objection may waive your right to raise the issue on appeal. If during the opposition's interrogation of a witness you make an objection that is overruled or ignored, so opposing counsel is permitted to continue asking questions that are improper, renew your objection with each such subsequent question and move the court to rule. If the court fails or refuses to rule, then at the close of your opposition presentation, renew your objection once more. If your objection does not sooner receive a favorable ruling, be sure to renew it at the close of the case before final deliberation begins. The general rule is this: if you don't object, you can appeal. However, in some circumstances, if you don't renew your objection, you didn't object, that's right, you must renew your objection so that the judge is given every chance possible to rule favorably on your objection. If a judge overrules your objection, the record is made, but you should still renew your objection when the opportunity again presents itself as explained above. If a judge ignores or refuses to rule on your objection, move the court to rule, and then, if the judge still refuses to rule favorably, object again. Then renew your objection as described above so the court's errors is clearly established on the record. Otherwise, you may lose valuable rights for appealing the judge's errors. First, object at the time of the error. Then renew all objections the judge overruled, ignored, or refused to rule upon. In particular, renew your objections to the judge's refusal to rule on objections. By renewing objections prior to the court's taking action that allows or ignores an error, you emphasize the error on the record and prepare your case for a reversal or remand by the appellate court that will see from the record you did everything possible to prevent the judge from moving forward after the error occurred. So, if during jury voir dire you object to a particular juror being excluded by the other side and the judge overrules your objection, then at the close of voir dire and before the jury is sworn, you must renew your objection to that juror or lose the right to object later. Or if during cross-examination a witness by the other side improper questions are asked and your objection is ignored or overruled, when that witness is excused, renew your objection, and again at the close of your opponent's presentation of his case, renew your objection, and finally at the close of the entire case before it is considered for final judgment, renew your objection once again. Remember, the judge's error is the sole basis for appeals. Nothing else is. We object to what the other side does because we want the judge to rule against the other side and put a stop to the error so it does not harm our case. However, it is the judge's error, either his failure to sustain or object our objection or his refusal to rule on them, that forms the basis for appeal. The other side will try to get away with whatever smoke and mirrors games it can come up with to hide the truth and confuse the court against you. Don't think for a moment that the other side will play fair. It is not to be expected. Errors will be made by the other side, but you cannot appeal the other side's errors. You object to them. Then, if the judge overrules or ignores your objections, you object to that as well and make your record of the judge's errors. You prepare for appeal by objecting to every error, the other side's errors and the judge's errors. However, on appeal, it's only the judge's errors that are under scrutiny. If you don't object to the judge's errors, the appellate court has nothing to reverse or remand. If you spend much time reading appellate decisions where a case is reversed or remanded for processing 4 proceedings consistent with the appellate court decision, you will see that at no time does the appellate court order your opponent to do anything whatever. In every case of this type, the appellate court corrects the errors of the judge and the judge alone. So after objecting initially to error, if a judge overrules your objection or refuses to rule, be sure to renew your objection before the court takes any final actions that would allow the error to impact your cause. After jury voir dire and before the jury is sworn. At the close of your presentation, at the close of your opponent's presentation, at the close of the case and before deliberation, and anytime it seems necessary to preserve your record for appeal. Very important. When we come back, we'll be talking about classes. Objections generally fall into one of 4 classes: evidence rule violations, procedural rule violations, general law violations, and polity and precedence violations. All right. So when we come back, we'll hit you guys with that.